Hey everyone, Lee Pacchia here coming to you from New York Law School. We're talking to Professor Leonard about the monumental gay marriage case that's going in front of the Supreme Court later this year. We unpacked the entire case in a previous interview, but I wanted to talk to the professor specifically about the one judge who could end up deciding this entire case. Professor, I want to drill down on Justice Kennedy, if I could. We were talking before about his decisions in not only gay marriage cases, but gay rights in general, and you said that they were a little bit unusual. Could you unpack that for us?
Yeah, he doesn't use the common terminology and language for constitutional law doctrine when he writes his gay rights decisions. He focuses very much on the facts. He focuses on the impact of the challenged laws on gay people, but he doesn't talk in terms of suspect classifications or heightened or strict scrutiny, which are terms of art in equal protection law. That has puzzled the commentators.
Yeah,
People,
why do you think
they're not
that is?
sure. Part of it is he may have developed his own view that laws that discriminate or exclude or treat same-sex couples as somehow not full citizens with the same rights as everyone else are just on their face inconsistent with our tradition of protection for liberty and equal protection under the 14th Amendment and the 5th Amendment in the case of federal policies. So he doesn't see the need to get into the more traditional kind of analysis because it seems clear to him, and evidently he's been able to persuade a majority of the court to sign on to these opinions, that it's enough to say that this is unequal treatment, this is a deprivation of liberty, that none of the arguments made to the court in support of it are substantial enough or objective enough to merit being credited as a justification.
So if he's the fulcrum in this case and he's the one ultimately that goes on to write the opinion and he continues this practice that has developed over time, what are the longer term implications?
Well, if he writes this opinion the way he wrote the Windsor opinion on the Defense of Marriage Act a few years ago in 2013, or the way he wrote the Lawrence opinion in 2003 striking down the Texas sodomy law, it seems to me that he will not be breaking new doctrinal ground. That what we will have most likely is a decision saying that these bans on same-sex marriage are the same sort of product of animus that the congressional ban on recognizing same-sex marriage was in the Windsor case. And in fact, that's the logic that a lot of lower courts have been using. They said this is just another application of the Windsor case. And so I don't think it would necessarily mean that we get heightened scrutiny in equal protection claims in other contexts, or that we have heightened scrutiny in due process claims in other contexts. It'll be interesting to see which provision of the Constitution he rests his decision on, whether it's the due process clause or the equal protection clause. If it's a due process decision, I think it may have less doctrinal weight in the future when we try to apply it in other contexts of government policies that disadvantage gay people.
Yeah, we were talking about that concept before we hopped on camera. What are some of the other different applications that this pending decision may or may not influence down the road? I mean, what types of areas are we talking
Well, the
about
biggest
here?
area is discrimination itself, because we still don't have a federal law banning discrimination based on sexual orientation. And the only pending federal law in that area really is the Employment Non-Discrimination Act, which just focuses on the workplace. And federal law in general focuses on many forms of discrimination in housing and public accommodations, and public services and things of that sort. So a decision on equal protection that actually recognized sexual orientation as a suspect classification or even a quasi-suspect classification, which would provide heightened scrutiny, which would put the burden on the government of justification, that would be a significant doctrinal breakthrough that would have strong consequences right off the bat in public employment, because public employers are bound by the 14th Amendment, even in a state that doesn't ban discrimination by statute. So a heightened scrutiny standard would be very helpful to gay public employees.
Wild stuff. Professor, thank you for stopping by and unpacking this monumentous case for us.
You're most welcome. We're looking forward to the outcome.
That's Professor Leonard from New York Law School. If you'd like to see more of this stuff they're working on, be sure to go check them out at nyls.edu. I'm Lee Pacchia. Thanks for watching.